Hi all, welcome to our HR Toolkit second podcast in the series. This one will be about the new law around sexual harassment. I'm Theo Saunders, part of the HR recruitment team here at Alexander Lloyd, and I'm joined today by Richard Bignell, who runs our HR people. So I guess we should probably start then, Richard, with you maybe giving us a bit of background around your sort of experience within employee relations and employment law.
Yeah, of course. So thank you for having me along for this again. I've been in HR for at all levels, I suppose, for around 24 years now. I now run my own HR consultancy, as you said, called Our HR People, and I work alongside business owners, leaders, boards, and managers to provide HR solutions to their business challenges. I think throughout my career, I've been responsible for everything from setting the people plans, setting the strategies, right through to the introduction of new policies and processes when they've been required and when the legislation changes. I personally have always had a strong bias towards employment law and matters around employee relations. And I've worked in organizations of all sizes, both unionized, non-unionized. And throughout that time, I've been responsible for anything from investigating straightforward disciplinaries, grievances, harassment claims, right the way through to managing complex discrimination claims at employment tribunal. I think, if we look over the past few decades, employment law has become more extensive and complex in its nature, and it's a constantly evolving challenge. With the recent general election and the Labour Party coming to power, I think it's now anticipated that there's going to be significant amounts of changes to employment legislation over the coming months. Massive amounts of changes on the cards.
No worries. What sort of, in regards to that, then what sort of changes do you sort of envisage coming or know that are coming? Or
So I think prior to the general election a few months ago, the Labour Party released a green paper basically detailing all of the changes that they're looking at making in the world of employment. And these include everything from the abolition of 0-hour contracts, removing the dismissal and re-engage option for employees, or fire and rehire, as a lot of people may know it, taking away day one rights. So at the moment, employees have to have 2 years service before they go to a tribunal for unfair dismissal. Now they would get those rights from day one. But also they're going to implement a single status of worker. So at the moment you have a status of employee, worker, agency worker, all self-employed. All of these are different statuses, but now they're going to have a single status for worker for everyone, apart from the genuinely self-employed. So there's a whole host of things coming our way, and that's just the tip of the iceberg.
yeah. So what will companies need to do then to get ready for these changes?
I suppose I guess my advice would be deal with what you know first. We're going to need to wait and see how the Labour Party actually deliver what they promised in their green paper and how it comes to fruition. It's going to need to go through a consultation process that's going to involve input from the unions, from businesses. So we need to see what actually happens when that comes to fruition. I'd say start by preparing for what like the changes to sexual harassment that we're going to be talking about today, and then maybe get further advice or wait for further information on the other elements. One thing's for sure, HR professionals will need to keep their ears to the ground over the coming months with all of these changes. They need to make sure they get updates from lawyers, read updates from the CIPD, but just whatever happens, keep your ear to the ground, I think is the key thing there.
Yeah, no worries at all. So in regards, obviously you just briefly touched on it today. So back to what we're sort of discussing today, what's the sort of impacts of upcoming changes to the legislations around sort of sexual harassment? What's that going to have?
I think this is one that's been, I think it's one of these ones that's widely reported in the HR press, but less so in the mainstream press. So a lot of companies may not be aware of the extent of these changes. But if I can take a step back, it's probably worth looking at what's in place already to protect people in the workplace.
Yeah.
I think this goes back, sadly, I still remember it, 2010, some 14 years ago, the
Yeah.
Equality Act came into force. And the Equality Act really was a way of consolidating a number of pieces of legislation, things like the Race Relations Act, sex discrimination, disability discrimination, a whole host of, I think there were about 9 pieces of legislation that were actually included and amalgamated into this one act. So part of the Equality Act intended to protect people against sexual harassment, as well as any harassment related to, I guess, protected characteristics. So it's really about ensuring that the mechanisms are in place to protect people.
Okay, well, briefly you said something there. So what do you mean by sort of when you talk about protected characteristics?
So protected characteristics are certain attributes that are safeguarded against discrimination under this Act of Parliament. So they include things like age, sex, disability, race, and even things like religion or philosophical belief. There's actually 9 protected characteristics, and it's illegal to either directly or indirectly discriminate against anyone based on any of those. And of course, the definition of those is sometimes tested. I think back in I think it was 2022, at a preliminary hearing, an employment tribunal was asked to determine whether support for Glasgow Rangers Football Club was recognised as a philosophical belief in terms of the Equality Act. And I'm sure a lot of football fans would feel the same. This claimant had been a supporter of Rangers for, I think it was 42, 43 years, most of his life. And he was a member of the club. He received birthday cards from them. He spent most of his disposable income on attending the matches, as well as on subscribing to Sky, so he didn't miss any matches that he didn't attend. Realistically, he never missed a match, and he actually considered supporting Rangers was a way of life, and that it was important to him as it was for a religious person to go to church. Now, the Equality Act says that a belief that's not religious can be a philosophical belief. So things like humanism, atheism, all classed as philosophical beliefs. And it doesn't actually need to include a faith or worship of a god or gods. But it needs to affect how that person lives their life or perceives the world. So you're sort of thinking, hang on, this being a fan of a football team, that might start fitting within this. There's 5 different tests, and I'm not going to go into the exact tests of that a tribunal applies, but there's 5 strict tests. Now, in this case, the claimant's claim was not upheld, but it does go to show that business owners and HR departments need to not just dismiss these claims out of hand without any sort of consideration. Initially you might sort of think, well, that's not right. Surely it doesn't represent a philosophical belief. But then when you start digging into it, you may find it does. And this part of the Act around religious or philosophical belief has actually been tested over time, including things like whether climate change represents a philosophical belief. It does, by the way, as well as claiming, being a Jedi Knight is a religion. It's all been tested. Now, on the other hand, I read another article back at the end of last year where tribunals in recent years have upheld a variety of philosophical beliefs as being worthy of protection. And these, things you wouldn't necessarily expect. So a belief that mediums can communicate with the dead was one. A belief in public service for the common good, a belief that lying is always wrong, and this is just naming a few. Again, this is really just to make people aware that sometimes the answers are not as straightforward as they first seem. You might sort of think, well, of course that's not, but when you start looking into it, you may find that it does get classed as a religious belief, for example. So it's often worth seeking advice and on these sorts of things. But coming back to the Equality Act and what we were talking about, the Act, among other things, has sought to protect individuals from sexual harassment and harassment. But what we're talking about today, I guess, is the sexual harassment side.
Yes, I mean, by the sound of that, you have really got to be careful, haven't you, and sort of delve into every case individually.
I think that's it. You have to be really just be aware that
Mm.
it's not just automatically reject these things out of hand. Give them
Yeah.
due consideration, and if needed, take some advice.
Yeah. If it doesn't sound, reasonable to you, doesn't mean
Mm,
it's not reasonable to that certain individual. So
completely.
yeah, sort of coming back to sort of sexual harassment in the workplace, right? Um,
Yeah.
is that,
And I think that with sexual harassment in the workplace, I think workplace is probably the right thing to say, because it's not necessarily just about people in the work and employees that get affected by this. It can cover
Mhm.
people outside of the workplace too. It's about what happens to individuals in work. So it can apply to employees, workers, contractors, self-employed people that you hire to personally do the work. But also one that people often forget is it applies to job applicants as well. And I'm
Yeah.
sure that you've seen that people have to be very careful um, when going through an interview process, that they're not discriminating or harassing individuals without knowing it. It's a really important piece of legislation. Employers can't just consider their own employees. They have a duty of care to consider the well-being, the psychological safety of others that are working with and for them.
Hmm.
And as we go through today, if I sort of refer to employees, bear in mind that I'm talking about everyone that's covered by this act.
Yeah.
It often applies to other people as well.
So when you touch there on sort of job applicants, occasionally as an agency, obviously we're hired to find the best person for a job. Occasionally
Mm,
that may maybe sort of say, for this example, a heavily male dominated sort of sector, and the hiring manager
mm,
or hiring team have said we want a female for this role. So then obviously,
mm.
you try and sort of tick their boxes. But so if we were to then, you get your applications through, but we sort of discount, I guess, sort of males. For an example, would that fall on
Yeah,
us, the sexual
I
harassment? So
suppose this is less sexual harassment or sex discrimination.
yeah,
But you have to be very careful and say,
right,
well, who is the best person for the job here?
right,
Just because this person is a male or a female doesn't necessarily impact their job. Now, if you have a genuine occupation or genuine business reason for needing a male rather than a female,
yeah,
then that may in itself be a defense. But in my experience, it needs to be quite a substantial
yeah,
defense. So, if you own a theatre and you're putting on a production and you're looking for actors and you need someone to come and play the lead female role,
right,
that may be a defense in itself. But my instant response is always that it's very unlikely to get a justified defense in most
yeah,
cases. I think that you need to judge people based on their merits, their behaviors, their values, their attitude, all of
yeah.
those different things, and not on any of those protected characteristics.
Perfect. So yeah, sorry, I digressed a little bit there.
That's all
But yeah,
right.
as you were sort of talking then, so I guess the law, so it concerns other individuals that aren't employees then.
Yeah, completely. And actually, one of the areas that companies often overlook is the need to protect their employees from experiencing sexual harassment from customers, from clients, members of the public. An employer needs to take steps to prevent this. Now, you may say, hang on a minute, I can't control what a member of the public does. I've got no jurisdiction over them. And to this, I would say absolutely understand what you're saying. However, companies need to ensure that any act that strays into a physical sexual assault, anything that constitutes a criminal act, of course, will report to the police, the relevant
Mhm.
authority. But beyond this, it's important for businesses or HR teams to risk assess those individuals that are being placed into a client or public-facing role, um, and think this can really ensure that employees, workers understand their level of authority. Now, by that, I mean that if an employee believes they're subjected to sexual harassment from a client or a member of the public, you need to make sure that they know and are comfortable with what steps they can take. So,
Mhm.
can they just walk off site? Can they walk away from the client? Can they hang up the phone? They need to understand what they can and what they can't do.
Yeah,
Um, It's also important for in the risk assessment to ensure that the employee or the worker has the ability to be able to report these incidents. And what I think is more important is the ability, as well as the ability to report these incidents, is know how to do that. So you need to make sure not that you just have the tools to be able to report, but they need to be aware of how they go about raising any complaints and what they have to do.
Perfect. So how do people know if something's sort of classified as sexual harassment? Is
I think you have a fairly clear, albeit slightly wide,
Yeah,
definition of what is classed as sexual harassment. And I think the first thing to consider is that the behavior needs to be unwanted and of a sexual
right.
nature. So the first thing is it needs to be unwanted. The second thing is it needs to have had the effect of violating someone's dignity, whether they intended it or not, or creating an intimidating, hostile, degrading, humiliating or offensive environment. And again, that's whether they intended it to do that or not. Sexual harassment is one of the most sensitive employee relations issues you can face as a business
Mhm.
owner, a business leader, or an HR professional. And it can involve anyone from junior employees to senior management. It's become highly topical for HR practitioners in recent years, following the Me Too movement in 2017,
Mhm.
with employees understandably and rightly expected to take a more robust approach to sexual harassment complaints. I think it's something that is and will remain topical.
Perfect. So by the sounds of that, whether the sort of employee intended to sexually harass the person or not is irrelevant.
Yeah, I mean, it's not relevant, no. It's of course something that would be borne in mind in deciding what actions to take, though. A
Yeah,
worker's conduct may still amount to sexual harassment, even if there's no sexual motivation on the part of the accused. As long as the conduct's actually of a sexual nature and meets the requirements that we talked about a moment ago, it's
yeah,
likely to be classed as sexual harassment. And the guidance is fairly clear that sexual harassment can occur when the conduct comes from the same or different sex, meaning sexual harassment cases may not always involve, for example, a male who's being accused and a female victim.
right.
Although research does confirm that is often the case. Sexual harassment doesn't include conduct that's consensual. If it's
Yeah,
consensual behavior, then that doesn't get included in sexual harassment. It has to be unwanted in order to be classed as sexual harassment.
okay. So have you got sort of some examples of sexual harassment or
I think it comes in many forms. I think a lot of people think when you talk about sexual harassment as being more the overt physical conduct, but
yeah,
there is also more subtle conduct that's sexual in nature. And I think often in offices the term banter gets thrown around, which
yeah,
I'm sure we'll talk a bit more in detail on in a moment. But I often hear banter used as a defence, and that's often not the case. But in terms of the actual behaviours, I guess you can have people engaging in physical behaviour, so that physical sexual assault, making sexual comments, jokes, looking or leering at someone, making propositions or sexual advances, uh, asking intrusive questions about a person's private or sex life, but even displaying sexually graphic pictures or posters in the office. And I think as a society, we've moved on slightly from having those page-free pictures on the walls. We know this is not acceptable.
yeah.
Um, and I think, as I say, we've moved on slightly from that now. But all of those different behaviours can be classed as sexual harassment. For example, a worker may sexually harass a co-worker by sharing those pornographic images, and a co-worker doesn't wish to see them,
Yeah.
refuses to see them. Um, workers' conduct will still amount to sexual harassment, even if there's no sexual motivation on part of the accused, as long as the conduct of a sexual nature and meets the other requirements. It's likely to be classed as sexual harassment.
I mean, it sounds like the law's pretty clear. So what's going to sort of be changing later this year then?
Yeah, I get what you're saying. A lot of the protection is in place, but I think we need to consider whether the current legislation is actually making a difference here.
Yeah,
Um, the protection's certainly there once an incident has occurred. However, when you consider, I think there was a recent survey by the Government Equalities Commission around sexual harassment, and it was scary that things like 72% of the UK population have experienced at least one form of sexual harassment in their lifetime.
wow,
And actually around, 40, 43%, something like that, have experienced at least one sexual harassment behavior in the last 12 months. It's still occurring too often.
wow,
And you think when of those cases that reported, around 20% of those, 21% of individuals are experiencing sexual harassment on a weekly basis. And the same number are experiencing and receiving sexual harassment on a monthly basis. And these are damning statistics. However, the one that is the most shocking to me is that only a staggering 33%, so around a third of the individuals that experience sexual harassment actually report it. So
oh
this
wow,
means that two-thirds of people that are experiencing some form of sexual harassment are not reporting. And, this is for me, this is just not acceptable. This is why
yeah.
new legislation is being put into place, to be honest.
Well, why do you think that is? The people aren't reporting it, or
Why they're not reporting? Yeah, I think the main reasons that were given in that study were Um, firstly, reporting it wasn't worth the hassle, so the process to go through was deemed as being too much of a hassle to go through. But scarily, that they didn't think that the reporting would help, or that indeed any action would be taken. As a society, I don't think we can accept this, and that's why this new legislation is in place. And the
mm,
legislation is the new Worker Protection Act that's coming into force. Comes in on the 26th of October this year, so we're not long now before that's in.
yeah,
And it goes a step further than the original provisions of the Equality Act that we were talking about, and puts that new mandatory duty on organisations, business leaders, and HR teams to take reasonable steps to prevent sexual harassment. So, and it's vital when looking at this subject, not just to look at the legal point of view, but also we know as within HR teams that businesses need to create psychological safety. And we know that when employees feel safe in the workplace, all of the people metrics improve, from
yes.
absence to turnover to engagement. So as well as the legal side here, you also have the moral side about looking after the employees in the workplace.
I mean, from that then, so it sounds like it's more proactive rather than reactive. Is that?
Yeah, exactly that, Theo. At the moment, there's no responsibility
Yeah,
or accountability on companies to prevent sexual harassment. The legislation in force at the moment purely focuses on what to do if sexual harassment occurs and making sure that you have all of the mechanisms in place to deal with that. But this new law really means that employers will need to take reasonable steps to prevent sexual harassment from occurring in the first place. So it is very much proactive and a preventative measure. How do we stop it before it actually happens?
so will there be any sort of consequences in getting that wrong, and what happens if companies do get that wrong?
Yeah. So there are, I mean, ultimately there could be serious consequences in terms of failing to comply with it, in terms of
Yeah,
the Equalities and Human Rights Commission's got a wide range of powers that they are able to enforce if companies are not following their duties in this new legislation. So they can conduct external investigations into any breach. They can require disclosure of evidence. They can issue unlawful act notices. But additionally, if an employee actually takes a company to tribunal alleging sexual harassment, the tribunal can actually uplift any compensation award to the employee by 25% or up to 25%. Just because these new duties and these new responsibilities are not complied with or not complied with sufficiently. In either case,
yeah,
there's also a reputational issue here as well to consider. So I think it's crucial for employers to comply with all of this legislation. And the key for me is to take steps now to prepare for this new duty, because it's no good waiting until the 26th of October when everything needs to be in place. We need to start thinking about it now.
Yeah, I mean, I'm sure sort of some people listening will be thinking sort of we need to still keep the working environment fun.
Yeah.
And you mentioned it a little bit earlier, sort of like, and inevitably there will still be some banter that goes on. So
Yeah, absolutely. And I get what you're saying, and I do understand that we need to continue to make workplaces an enjoyable environment. Look, we spend the majority of our waking lives in work, so we need to make sure that we actually enjoy it. But
yeah,
without being too facetious, I've read the legislation, and there is no mention of the word banter in there.
okay,
I think that there's always a line when it comes to
yeah,
this banter or jokes in the workplace as to when it goes too far. And I think we need to go back to what we were talking about earlier around this behavior needs to be unwanted conduct. Now, the challenge with condoning jokes, banter in the workplace is that unwanted conduct for me is going to be very different from what you deem as unwanted.
yeah,
And, whenever I advise clients and have advised clients previously, I've always said that they need to manage this risk. They're the ones that know the teams. They know what they believe they will find acceptable. The way to completely protect yourself is have a zero tolerance rule. But if you think actually my team are okay with this level of banter and I'm willing to take that risk, that's fine. But allowing it in the workplace comes with risk, and someone may not be happy with it. Having jokes and banter in the workplace is never a problem until it's a problem.
yeah,
And then suddenly, oh, I didn't see that coming. So you just need to be really, really aware of this legislation and the impact of, allowing these jokes in the workplace and the banter in the workplace, and knowing at what point this stops and becomes into that unwanted conduct.
So what can we do to prepare then?
So I think, as I said, we need to start looking at this now. People need to be
Yeah,
preparing for this. So there's a number of ways they can do this. And I think the first thing is looking at the culture of the organization. It needs the culture needs to reinforce the legislation and not have a zero tolerance approach to harassment. The thing with culture, however, is I guarantee you that culture will never be truly embedded if it's not role modeled from the very
yeah,
top. It needs to be lived in everything the company is and everything the company does. So if it's not believed from the top, it's not worth doing, because it will never be truly embedded.
yeah,
And of course, having things like a sexual harassment policy is important. But interestingly, with this new legislation, just having a policy on its own is not enough to comply with the new legislation. Companies, when they have a policy, need to make sure it's kept up to date, communicated, and understood by all individuals in the organization. Companies should look at training. I think specific training on what sexual harassment is and how staff can make complaints. This can include training for managers, training for employees. As with all discrimination training, again, important to keep it up to date and keep it relevant. So getting in external training often can really help to upskill your teams. But one area that I also recommend implementing training on is having external bystander training. So this is training that you'd roll out to all of your workforce about what to do if they see something that's inappropriate. How do they deal with it? How do they deal with it as a bystander to this potential harassment? I talked about reporting mechanisms already, but it's important to have clear reporting lines that everybody knows about, so that they can disclose incidents of sexual harassment or any harassment come to that. And one of the ways that a lot of companies are going with this is to have a clear reporting tool or a confidential reporting line So I work with a company called iReport, who can provide companies and their employees with an anonymous reporting line. So an employee can contact this external company, in this case iReport. They can contact them, usually either via a form or via a chat bot. They can register their complaints and their details, and then that company will be either speak to the senior leaders of the organization about it. They can actually investigate it, and action can happen because of that. It just taking that reporting mechanism out of the company just demonstrates that impartiality even more. And last but not least, the risk assessments we talked about already. People need to put in place risk assessments, particularly with those employees that are out in client-facing and public-facing roles. As we mentioned earlier, they can identify areas of risk and put in place clear plans to deal with those. As I said, the working with clients and customers is one that people often forget when it comes to sexual harassment. No matter what, all complaints of sexual harassment must be investigated immediately in detail. During investigations, companies have got a duty to ensure the investigation's fair to complainants, the respondent, and of course any other witnesses as well. So it's often quite a sensitive thing conducting investigations into sexual harassment.
Perfect. So what if companies have already got sort of policies and procedures dealing with sexual harassment? Is it about sort of reviewing them, or?
To a certain extent, yes. Many employers will already have policies, procedures in place that deal with sexual harassment complaints. So it may be a need to update that. And while it might mean that employers are currently compliant, it might not be enough to comply with the new mandatory duties, which requires a more proactive approach. It's important that employers review current practices and by all means reach out to companies like mine, our HR people, to support in getting ready for this, because as I said earlier, it's a piece of legislation that seems to have gone by without being reported on massively, apart from within the HR press. So I think people just need to start preparing now.
Yeah. So what can companies or HR teams do if they receive a sexual harassment complaint? What's their sort of
I think if a complaint comes in of sexual harassment or any harassment, as we said, whether it's before or after these new mandatory duties come in, you could investigate it promptly, thoroughly. This means meeting all of the relevant witnesses, gathering the relevant facts, preparing an investigation report, and any recommended outcomes. Sexual harassment investigations, as I said, are particularly sensitive and sometimes require additional steps above and beyond the normal workplace investigation. And it might include consideration as to the gender, the impartiality of the investigator. How do you preserve anonymity for those involved, and also whether you need to put in place any safeguards to protect staff while the investigation is taking place. And that could be temporary suspension of the accused or reassigning staff to different teams just while the investigation is going on. And I'm sure I'd always say this, but I would always advise speaking to someone like myself, our HR people, due to the higher risks to the business that can arise from sexual harassment. Likewise, if anyone listening would like any assistance with designing, running training for their employees or workers, or external bystander training, or indeed if they'd like any other assistance in ensuring they're ready for this significant change, then obviously feel free to reach out and contact me.
Perfect. I think that's pretty much covered, unless anything else you wanted to add, Richard?
No, I think that's it. I think it's just my only advice to companies is just, don't wait on this. Start getting ready for it now. Yeah,
definitely be ahead of the game.
Exactly.
Perfect. Well, thank you very much for your time. I'm sure a lot of people find that very insightful. I did. There was things in there that you don't necessarily think of. So it's always good to have those highlighted, and better to be cautious than sorry, I guess.
Yeah, absolutely. Well, thank you for having me. It's been great.
No worries at all. Take care, Richard.
Take care. Bye.
Cheers. Bye.